Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. My experience has been when individuals file a lawsuit, they believe they have a good faith basis for doing so. And also, they have every intent of seeing the lawsuit all the way through. But sometimes situations occur where a litigant cannot continue the lawsuit. Hardship based on finances, medical hardship, emotional hardship. And that's what we are going to talk about today. The plaintiff voluntarily dismissing the lawsuit to preserve the right to file the claim again. It's called a voluntary dismissal without prejudice. So let's look at without prejudice and with prejudice. A case dismissed without prejudice means the case is not dismissed forever. The person whose case it is can try again. A case dismissed with prejudice is over and done with once and for all and can't be brought back to court. It's important that the plaintiff or the litigant understand the difference between without prejudice and with prejudice. But for the purposes of this video, we're going to talk about without prejudice. Federal Rules of Civil Procedure 41 governs dismissals. 41A addresses dismissals without the court order. Next, we're going to discuss 3 instances in which a plaintiff can file a dismissal without a court order. 1, the plaintiff must serve a notice of dismissal before the opposing party serves an answer to the plaintiff's complaint, or before the opposing party serves a motion for summary judgment. Now, at this stage, the defendant and the plaintiff, both parties, have invested a lot of time and money. Not every jurisdiction would allow a plaintiff to dismiss the complaint at this stage, mainly because of the money and the time that has been invested. So the plaintiff would need to know that jurisdiction's rules regarding dismissing a complaint at such a later time. And 3, or a stipulation of dismissal signed by all parties who have appeared. Now, with regards to the notice that the plaintiff submits or the stipulation that the parties agree to, if it does not include the words without prejudice, the dismissal is presumed to be without prejudice. But you see my little friend biting his fingers? I don't blame him because my practice is to ask the party to include the words without prejudice in the notice or stipulation. And if the parties agree, there should not be an issue including those words. Otherwise, if a lawsuit is not dismissed pursuant to the 3 instances we just discussed, it may be dismissed at the plaintiff's request only by court order on terms that the court considers proper. And you can read that at Federal Rules of Civil Procedure 41A, subsection 2. Now, if the plaintiff previously dismissed any action, whether it was a federal court or whether it was in state court, based on or including the same claim, a notice of dismissal operates as an adjudication on the merits or the law and the evidence. Now, the way I interpret this is absent a law or a statute that would permit the plaintiff to refile the claim based on a non-merit argument, it appears the claim cannot be refiled. I trust this has been helpful to you. And until next time, be empowered.